Hello, welcome to Wiser Pinoy TV. This is your host, James Vilon, a history and political science practitioner and a law student. For today, we will be discussing the alternative circumstances under the revised Penal Code. When we talk about alternative circumstances, we always consider four things. One is relationship. Second is intoxication. Third is degree of instruction. And lastly, education. Now, for the future registered criminologists and law students also as well, you use only the term alternative circumstance for as long as the particular circumstance is not involved in any case or problem. Meaning, the moment it is given in a problem, do not use alternative circumstance and refer to it as aggravating or mitigating depending on whether the same is considered as such or the other. If the relationship is aggravating, refer to it as aggravating. And if it is mitigating, then refer to it as such. Except for the circumstance of intoxication, the other circumstances in Article 15 of the Revised Penal Code may not be taken into account at all when the circumstance has no bearing on the crime committed. So the court will not consider this as an aggravating or mitigating simply because the circumstance has no relevance to the crime that was committed. Do not think, guys, that because the article says that these circumstances are mitigating or aggravating, that if the circumstance is present, the court will have to take it as mitigating. If not mitigating, it would be aggravating. That is wrong. It is the circumstance of intoxication which, if not mitigating, is automatically aggravating. But the other circumstances, even if they are present, but if they do not influence the crime, the court will not consider it at all. Relationship may be also considered as an aggravating depending on the commission of the crime. Degree of instruction also will not be considered if the crime is something which does not require an educated person to understand. Okay, let us now start with relationship. Now, under the revised penal code, relationship is not simply mitigating or aggravating. There are specific circumstances where a relationship is exempt. Among such circumstances are: 1. In the case of an accessory who is related to the principal within the relationship prescribed in Article 20 of the Revised Penal Code. Second, also in Article 247, a spouse does not incur criminal liability for a crime of less serious physical injuries or serious physical injuries if this was inflicted after having surprised the offended spouse or paramour or mistress committing actual sexual intercourse. Third, those commonly given in Article 332 of the Revised Penal Code when the crime of theft, malicious mischief, and swindling or estafa. There is no criminal liability but only civil liability if the offender is related to the offended party as spouse, ascendant, or descendant, or if the offender is a brother or sister or brother-in-law or sister-in-law of the offended party, and they are living together. Exempting circumstance is the relationship. This is an absolutory cause. Sometimes relationships are qualifying and not only a generic aggravating circumstance. In the crime of qualified seduction, the offended woman must be a virgin and less than 18 years old. But if the offender is a brother of the offended woman or an ascendant of the offended woman, regardless of whether the woman is a bad reputation, even if the woman is 60 years old or more, crime is qualified seduction. In such a case, the relationship is a qualifying. Now let's proceed to the intoxication. This circumstance is ipso facto mitigating, so that if the prosecution wants to deny the offender the benefit of this mitigation, they should prove that it is habitual and that it is intentional. The moment it is shown to be habitual or intentional to the commission of the crime, the same will immediately aggravate regardless of the crime committed. Intoxication to be considered mitigating requires that the offender has reached that degree of intoxication whether he has no control of himself anymore. The idea is the offender, because intoxication is already acting under diminished self-control. This is the reason why intoxication is mitigating. So if the reason is not present, intoxication will not be considered mitigating. So the mere fact that the offender has taken one or more cases of beer of itself does not warrant a conclusion that intoxication is mitigating. There must be indication that because of the alcohol intake of the offender, he is suffering from diminished self-control. There is diminished voluntariness insofar as his intelligence or freedom of action is concerned. It is not the quantity of alcoholic drinks, rather it is the effect of the alcohol upon the offender which shall be the basis of the mitigating circumstances. Now, let me explain it with an illustration. In case there were two laborers who were the best of friends, since it was payday, they decided to have some good time and ordered beer. So when they drank 2 cases of beer, they became more talkative until they engaged in an argument. One pulled out a knife and stabbed the other. When arraigned, he invoked intoxication as a mitigating circumstance. Intoxication does not simply mean that the offender has partaken of so much alcoholic beverages. The intoxication in law requires that because of the quality of the alcoholic drink taken, the offender had practically lost self-control. So although the offender may have partaken of 2 cases of beer, but after stabbing the victim, he hailed a tricycle and even instructed the driver to the place where he is sleeping and to reach his house, and so he has a light and walk to his house, then there is no diminished self-control. The Supreme Court did not give the mitigating circumstance because of the number of wounds inflicted upon the victim. There were 11 stab wounds, and this, the Supreme Court said, is incompatible with idea that the offender is already suffering from diminished self-control. On the contrary, the indication is that the offender gained strength out of the drinks he had taken. It is not the quantity of drink that will determine whether the offender can legally invoke intoxication. The conduct of the offender, the manner of committing the crime, his behavior after committing the crime must show the behavior of a man who has already lost control of himself. Otherwise, intoxication cannot legally considered. Now let's proceed to the degree of instruction and education. These are 2 distinct circumstances. That is why earlier I separated them in my enumeration. One may not have any degree of instruction but is nevertheless educated. For example, A has been living with professionals for some time. He may just be a maid in the house with no degree of instruction, but he may still be educated. It may also happen that the offender grew up in a family of professionals. Only he is the black sheep because he did not want to go to school, but it does not follow that he is bereft of education. If the offender did not go higher than grade 3 and he was involved in a felony, he was invoking lack of degree of education. The Supreme Court held that although he did not receive schooling, yet it cannot be said that he lacks education because he came from a family where brothers are all professionals, so he understands what is right and wrong. And take note, guys, that the fact that the offender did not have the schooling and is illiterate does not mitigate his liability if the crime committed is one which he inherently understands as wrong, such as parricide. If a child or son or daughter would kill a parent, illiteracy will not mitigate because the low degree of instruction has no bearing on the crime. In the same manner, the offender may be a lawyer who committed rape. The fact that he has knowledge of the law will not aggravate his liability because his knowledge has nothing to do with the commission of the crime. But if he committed falsification, that will aggravate his criminal liability where he used his special knowledge as a lawyer, then it will become also material. So thank you very much. I hope that you have learned about the alternative circumstances. This is James Vilon, and thank you for watching this video. Do not forget to like, subscribe, and comment also down your ideas and opinions to improve this video. Thank you very much, and mabuhay kayo mga future registered criminologists.